everyone. The topic for today's lecture is Investigation under the Companies Act 2013. The objectives of this lecture are to understand the concept of investigation, to make the students understand about the procedure of investigation under the Companies Act 2013, to discuss the power of inspector under the Companies Act 2013, and to discuss the various powers of Serious Fraud Investigation Office under the Act. Generally speaking, an investigation is a thorough search for facts, especially those that are hidden or need to be sorted out in a complex situation. The goal of an investigation is usually to determine how or why something happened. Investigations are usually formal and official. Since the shareholders themselves are unable to supervise and ensure efficient functioning of the companies, the organized supervision by government agencies assumes significant role. It's only efficient and smooth functioning of the corporate that can ensure an adequate return on capital invested by the shareholders. In Barium Chemicals Limited, the Supreme Court observed the elementary philosophy of the Companies Act is to trust the shareholders for ensuring efficient performance. But for reasons more than one, the shareholder has already receded to the background. Firstly, he is an investor who, for the most part, does not wish to be bothered except by dividends. Secondly, due to great diffusion of stock, shareholders become indifferent to voting and controlling. Thirdly, the shareholders are ill-equipped to challenge the wisdom and expertise of officers. Fourthly, few shareholders have the means or ability to act against management. Section 210 of the Companies Act 2013 talks about investigation into the affairs of company. Subsection 1 talks about investigation in the opinion of central government. According to this subsection, the central government may order and appoint inspectors for investigation into the affairs of the company under the following three conditions. Firstly, on the receipt of a report of the registrar or an inspector under Section 208. On intimation of a special resolution passed by the company that the affairs of the company ought to be investigated, suo motu, in public interest. Subsection 2 talks about investigation on the order by a court or the tribunal. According to this subsection, where an order is issued by a court or the tribunal in any proceedings before it that the affairs of an establishment are required to be investigated, the central government shall order an investigation into the affairs of that company. Section 211 of the Companies Act 2013 talks about the establishment of Serious Fraud Investigation Office. The central government shall, by notification, establish an office to be called the Serious Fraud Investigation Office to investigate frauds relating to a company, provided that until the Serious Fraud Investigation Office is established under subsection 1, the Serious Fraud Investigation Office set up by the central government in terms of the Government of India Resolution number 45011-16 of 2003 dated the 2nd July 2003 shall be deemed to be the Serious Fraud Investigation Office for the purpose of this section. The Serious Fraud Investigation Office shall be headed by a director and consist of such number of experts from the following fields to be appointed by the central government from amongst persons of ability, integrity and experience in banking, corporate affairs, taxation, forensic audit, capital market, information technology, law or such other fields as may be prescribed. The central government shall, by notification, appoint a director in the Serious Fraud Investigation Office who shall be an officer not below the rank of a joint secretary to the Government of India having knowledge and experience in dealing with matters relating to corporate affairs. The central government may appoint such experts and other officers and employees in the Serious Fraud Investigation Office as it considers necessary for the efficient discharge of its functions under this Act. The terms and conditions of service of director, experts, and other officers and employees of the Serious Fraud Investigation Office shall be such as may be prescribed. Section 212 talks about the investigation into affairs of company by Serious Fraud Investigation Office. According to this section, when the central government is of the opinion that it's necessary to probe into the affairs of a corporate by the Serious Fraud Investigation Office, it may, by order, assign the investigation into the affairs of the said company to the Serious Fraud Investigation Office. On receipt of such order, the Director, Serious Fraud Investigation Office may designate such number of inspectors as he may consider necessary for the conduction of such investigation. Where any case has been assigned by the central government to Serious Fraud Investigation Office for investigation under this Act, no other investigating agency of central government or any state government shall proceed with investigation in such case in respect of any offence under this Act. However, if any such investigation has already been initiated, it shall not be proceeded further. Where the investigation into the affairs of a firm are assigned by the central government to Senior Fraud Investigation Office, it shall conduct the investigation within the manner provided in Chapter 14, that is Inspection, Inquiry and Investigation, and submit its report to the central government within such period as may be laid out in the order. The company and its officers and employees who are or have been employed by the company shall be responsible to furnish all information, explanation, documents, and assistance to the investigating officer as he may require for conduct of the investigation. Offences covered under Section 447 of this Act shall be cognizable, and no one accused of any offence under those sections shall be released on bail or on his own bond unless the public prosecutor has been given a chance to oppose the plea for such release. And where the public prosecutor opposes the plea, the court is satisfied that there are reasonable grounds for believing that he is acquitted of such offence which he is unlikely to commit any offence while on bail. However, a person who is under the age of 16 years or is a woman or is sick or infirm may be released on bail if the special court so directs, provided that the special court shall not take cognizance of any offence referred in point 5 above except upon a complaint in writing made by the Director, Senior Fraud Investigation Office or any officer of the central government authorized by a general or special order in writing in this regard by that government. If any officer not below the rank of the Assistant Director of Senior Fraud Investigation Office authorized during this behalf by the central government has a reason to believe that a person has been guilty of any punishable offence under sections mentioned in subsection 6, he may arrest such person and shall inform him of the grounds of such arrest. All persons arrested shall within 24 hours be taken to a special court or judicial magistrate or a metropolitan magistrate having jurisdiction. The Senior Fraud Investigation Office shall submit the investigation report to the central government on completion of the investigation. On receipt of the investigation report, the central government may, after examination of the report, direct the Senior Fraud Investigation Office to initiate prosecution against the firm and its officers or employees, past or present, or any other person directly or indirectly connected with the affairs of the company. Where the report states that fraud has taken place in a company and owing to such fraud, any director, key managerial personnel, other employee of the company or any other person or entity has taken undue advantage or benefit, whether in the form of any asset, property or cash or in any other manner, the central government may file an application before the tribunal for appropriate orders with reference to disgorgement of such asset, property or cash, and also for holding such director, key managerial personnel, other officer or any other person liable personally with no limitation of liability. The Serious Fraud Investigation Office shall share any information or documents available with it with any investigating agency, state government, police authority or tax authorities which can be relevant or useful for them in respect of any offence or matter being investigated by it under other laws. Section 213 talks about investigation into companies' affairs in other cases. The tribunal may, on an application made by not less than 100 members or members holding not less than 1/10 of the total voting power in the case of a company having a share capital, or not less than 1/5 of the persons on the company's register of members in the case of a company having no share capital, and supported by such evidence as may be necessary for the purpose of showing that the applicants have good reasons for seeking an order for conducting an investigation into the affairs of the company. Or on an application made to it by any other person or otherwise, if it is satisfied that there are circumstances suggesting that the business of the company is being conducted with intent to defraud its creditors, members or any other person or otherwise for a fraudulent or unlawful purpose, or in a manner oppressive to any of its members, or that the company was formed for any fraudulent or unlawful purpose. Secondly, persons concerned in the formation of the company or the management of its affairs have in connection therewith been guilty of fraud, misfeasance or other misconduct towards the company or towards any of its members. Thirdly, the members of the company have not been given all the information with respect to its affairs which they might reasonably expect, including information relating to the calculation of the commission payable to a managing or other director or the manager of the company, order after giving a reasonable opportunity of being heard to the parties concerned that the affairs of the company ought to be investigated by an inspector or inspectors appointed by the central government. And where such an order is passed, the central government shall appoint one or more competent persons as inspectors to investigate into the affairs of the company in respect of such matters and to report thereupon to it in such manner as the central government may direct. Provided that if after investigation it is proved that the business of the company is being conducted with intent to defraud its creditors, members, or any other persons or otherwise for a fraudulent or unlawful purpose, or that the company was formed for any fraudulent or unlawful purpose, or any person concerned in the formation of the company or the management of its affairs have in connection therewith been guilty of fraud, then every officer of the company who is in default and the person or persons concerned in the formation of the company or the management of its affairs shall be punishable for fraud in the manner as provided in Section 447. Section 216 talks about the investigation of ownership of company. It says, where it appears to the central government that there is a reason so to do, it may appoint one or more inspectors to investigate and report on matters relating to the company and its membership for the purpose of determining the true persons who are or have been financially interested in the success or failure, whether real or apparent, of the company, or who are or have been able to control or to materially influence the policy of the company. Without prejudice to its powers under subsection 1, the central government shall appoint one or more inspectors under that subsection if the tribunal, in the course of any proceeding before it, directs by an order that the affairs of the company ought to be investigated as regards the membership of the company and other matters relating to the company for the purposes specified in subsection 1. While appointing an inspector under subsection 1, the central government may define the scope of the investigation, whether as respects the matters or the period to which it is to extend or otherwise, and in particular may limit the investigation to matters connected with particular shares or debentures. Subject to the terms of appointment of an inspector, his powers shall extend to the investigation of any circumstances suggesting the existence of any arrangement or understanding which, though not legally binding, is or was observed or is likely to be observed in practice and which is relevant for the purposes of his investigation. Now, to conduct the investigation, a wide range of powers have been vested in the inspector. They are the power to summon the officers, employees, including former officers and employees of the company, and other persons in relation to the company as they deem necessary. Require the body corporate to furnish information and produce such books and papers deemed necessary. Require any other body corporate to furnish information and produce such books and papers deemed necessary. Subject to the terms of appointment, the inspector may also investigate any circumstances suggesting the existence of any arrangement or understanding which, though not legally binding, is or was observed or is likely to be observed in practice. Seizure of documents if he has reasonable cause to believe that the documents can be mutilated or destroyed. Keep seized documents in his or her custody. In addition to this, the investigator is also vested with the powers of a civil court under the Code of Civil Procedure 1908 with regard to the discovery of books and documents, summoning and enforcing the attendance of persons on oath and inspection of any books, records, and other documents at any place. Now talking about the powers of National Company Law Tribunal. The tribunal may, either on a reference by the central government or on a complaint made under Section 244 or complaint by a creditor having Rs 1 lakh outstanding against the company or deems it necessary, freeze the assets of the company for a period of 3 years. The tribunal may, either on a complaint or suo motu in connection with an ongoing investigation, impose restrictions on the transfer, etc. of securities. Now, action by central government upon receipt of the report. Action by central government upon receipt of the report prosecute the officers and or employees if they are held guilty of offences that are criminal in nature. Order for winding up of the company, recover damages in respect of any fraud, misfeasance or other misconduct in connection with the promotion or formation or the management of the affairs. Recover property which has been misapplied or wrongfully retained. The Act imposes penalties in case of violation of the orders of the inspector and the tribunal. The following penalties may be levied. Disobedience of the direction of the inspector or registrar attracts imprisonment of up to 1 year and fine of rupees 25,000, extendable up to rupees 1 lakh or both on the directors and officers of the company under section 217, subsection 6. Disqualification and vacation of office of the directors under section 217, subsection 6. Non-furnishing of information, non-production of documents, non-appearance before the inspector, etc. attracts imprisonment of up to 6 months and fine of rupees 25,000, extendable up to rupees 2,000 for every day of default under section 217, subsection 8. Transfer of assets that are frozen by the National Company Law Tribunal attracts a fine of rupees 1 lakh, extendable to rupees 25 lakhs on the company and imprisonment of up to 6 months and a fine of rupees 25,000 extendable up to rupees 5 lakhs or both on the officers under section 221, subsection 2. Transfer of securities in contravention of the order of the National Company Law Tribunal attracts a fine of rupees 1 lakh, extendable to rupees 25 lakhs on the company and imprisonment of up to 6 months and a fine of rupees 25,000 extendable up to rupees 5 lakhs or both on the officers under section 222, subsection 2. Certain acts like destruction, mutilation, falsification of documents, provision of false information, etc. also attract criminal charges under section 447, under section 229. To conclude, corporate structures are often used to perpetrate illegal and fraudulent activities. These activities impact the other members, creditors, depositors, and the financial system in general. It is with the intent to nail such persons hiding behind the corporate veil that the Companies Act 2013 includes provisions on the investigation of ownership of companies. The law also provides wide powers to the inspector to perform their duties. These provisions are thus very critical towards building an environment of good corporate governance. So, that was all about investigation. Hope that you have understood the lecture. Thank you for watching.